30 seconds. Ten, 9, 8, 7, 6, 5, 4, 3, 2, 1. We're live.
Well, good evening, everyone. My name is Thomas Ure, and I am chairperson of the City of Morganton's Land Use Adjustment Board. And I want to welcome everyone tonight to our business that we have to conduct here. And I want to go ahead and convene the meeting. And we do have the first order of business tonight is a matter of minutes from a previous meeting that we conducted some time ago that I want to bring to the matter of the board. And I believe those minutes have been distributed for your review. And at this time, I would ask if you have had an opportunity to review those minutes, I would entertain a motion for their approval. Is there a motion to approve the minutes?
So moved.
Motion's been made to approve the minutes. Is there a second?
I'll second.
Motion's been seconded. Is there any discussion or questions concerning the minutes? In that case, I would ask for the yeas and nays. All in favor of the minutes from our most previous meeting being approved, please say aye.
Aye.
Opposed, like sign. In the consideration of the chair, the ayes have it. The motion passes. Well, again, I want to welcome you all, particularly in the audience and online and TV, to our meeting tonight. And I want to go over our order of business with you all as we convene. And with regard to our business as the Board of Adjustment, Land Use Adjustment for the City of Morganton, we're going to take up two matters tonight. Case number one, I'll refer to as the West Concord Street property. It's 2 lots. And then the second property is, the second case involves 2 lots that I'll refer to as the Lane lots. And both applications are for variances from the City of Morganton zoning ordinance. Just for the public's information, a variance application in order to be approved by this board requires a 4/5 vote in the affirmative. That means 4 out of 5 of the board members here tonight have to approve moving forward with the variance request. Before we begin tonight's consideration of those 2 matters, it's important for everyone participating or watching tonight to understand some important facts related to this meeting. This Board of Adjustment meeting is known as a quasi-judicial proceeding, which means it functions much like a court proceeding in which one's individual's rights are being determined. Testimony will be limited only to those issues concerning whether the applications should be approved for variances. The legal purpose of this quasi-judicial hearing is not to gather public opinions and suggestions as to the policy to be applied. The policy has already been set forth in the zoning ordinance for the City of Morganton. This board is making the decision to apply those existing policies to a specific application, or in this case tonight, 2 applications. The purpose of the evidentiary hearings that you're going to witness or participate in tonight is to gather legally sufficient factual evidence to apply those standards to the application based upon competent, material, and substantial evidence in the record. Are there any members here tonight who feel like they cannot sit as an impartial decision maker in today's proceeding due to a conflict of interest? Members of the board, I as your chair, am interested in one of the matters tonight, the Lane property. In reviewing the materials ahead of time, it occurred to me that I may have a conflict of interest. With your permission, at the time that we get to that matter, I'd like to ask the applicant some questions to determine whether or not I have a conflict, and if so, disclose that matter to you at that time and get you to weigh in and whether or not there's a need for me to recuse myself at that time. Are you comfortable with us proceeding under those circumstances? Any objections? Hearing none, we'll proceed accordingly. The order of business for this hearing will be for each case as follows. So we will swear in anyone giving testimony before this board this evening regarding the applications first and foremost. And then we'll proceed in this manner. First, we'll have the senior planner from the Morganton Development and Design Department to provide an overview of the application. Of course, the Morganton Development and Design Department will not be providing any opinions to this board, will not be advocating a position one way or the other, just merely providing an overview of the application. Board members will in turn have the opportunity to ask the design official any questions they deem appropriate. We'll proceed in an orderly fashion in that questioning format. Then we will hear from the applicant for each application, who will present evidence in support of the request and answer any questions from the board about the evidence presented. Anyone else who has expressed a desire to be a party and who the board has recognized as a party will then be allowed to present their evidence. All parties will be given an opportunity to ask questions of all parties, witnesses testifying in this proceeding. Board members will be given an opportunity to ask questions of any additional parties recognized as such by the board. For our deliberations tonight, in order to be considered a party, you must meet any of the following criteria. A, you have an ownership or contractual interest in the property that is the subject of the matter before the board. B, you are the applicant. C, you are a person who will suffer special damages as the result of the decision being appealed. Special damages are actual damages to which you can provide evidence to this board. And then D, you're a representative of an incorporated or unincorporated association, such as a homeowners association here tonight. And then fourthly, for anyone wishing to be heard as a non-party participant, and you want to make a presentation here tonight, you want to speak, you will be given that opportunity. This board has traditionally allowed folks to do that. We will hear you. The board's request is that you limit your remarks to the issues involving the application. This board is not a policy-making body. I want to reiterate that. Moreover, if another speaker ahead of you has already presented your position or points for the sake of efficiency, the board would appreciate you not being repetitious. All persons who speak and participate will be placed under oath. Witnesses may also choose to affirm. If you want the board to see written evidence such as reports and maps or exhibits, the witness who is familiar with the evidence should ask that it be introduced during or at the end of his or her testimony. In addition, in order for the testimony to be considered as evidence, it can only be given by a person in attendance at the meeting. Otherwise, it is considered hearsay and will not be received by this board. The variance requirements are set forth in our general statutes here in North Carolina law. Variances are described this way: when unnecessary hardships would result from carrying out the strict letter of a zoning regulation, the Board of Adjustment shall vary any of the provisions of the zoning regulation upon a showing of all of the following. In other words, every single one of these have to be shown to us tonight. Number one, there has to be an unnecessary hardship that would result from the strict application of the regulation or zoning ordinance. It is not necessary, however, to demonstrate that in the absence of the variance, no reasonable use can be made of the property. Number two, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. A variance may be granted when necessary and appropriate to make a reasonable accommodation under the Federal Fair Housing Act for a person with a disability. Number three, the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance is not a self-created hardship. Number four, the requested variance is consistent with the spirit, purpose, and intent of the regulation, or in this case, the zoning ordinance for the city of Morganton, such that public safety is secured and substantial justice is achieved. At this time, I would ask if their applicants are prepared to move forward. If you are here tonight, if you would stand and come forward for both cases, both the Connor Street property, what I would like to do for the efficiency of time, the Concord Street property, as well as the Lane Street property, if we could go ahead and swear you in at this time, along with our witness for the city of Morganton. Is anyone here for the Concord Street property? If you would come forward, please, ma'am. And is anyone here for the Lane Street property that's going to be speaking tonight? Okay, and so if you would please raise your right hand, and let's see here. Do we have a Bible? Does everyone feel comfortable swearing on the Bible? If you do not, then we'll have an affirmation. And indeed, I'll do it in such a manner that you can do both. Do you swear or affirm to tell the whole truth and nothing but the truth, so help you God? Thank you. You may be seated. At this time, we'll call forward the Connor Street application, and I would ask for Ms. Wendy Smith with the City of Morganton to come forward and give us an overview of the application for a variance with regard to that property or those two lots. Ms. Smith.
Good evening.
Good evening.
Chad, if you want to bring the property up on the screen, or the laptop. So this is a rough map of where the properties are. It is 311 and 313 West Concord Street. They are on the corner of Bay Street, which is a private street, or easement rather, there at the back of the Morganton Day School property. The request is to reduce the front setback of these lots in zone LID, the low intensity district, from 30 feet to 10 feet, and to reduce the rear setback from 25 feet to 10 feet. They are pre-existing lots that are approximately 50 feet wide or in depth at that, and with those existing setbacks in that zone, the setbacks would actually cross each other by 5 feet, rendering the lots completely undevelopable. So they are, however, historic existing lots with rights to development. So the request is to reduce the setbacks in that manner, and provided in your packet examples of homes that could be built on that lot should those setbacks be achieved. The applicant owns one lot, 311, and has an option, I understand, to purchase 313, and it is the intent to combine those lots to create the one larger lot for one single family home on that property, should the setbacks be, or should the reduction to the setbacks be approved through the variance. Any specific questions about anything in the materials previously presented as part of your packet?
Thank you, Ms. Smith. We will do that right now and start with Mr. Britton. Mr. Britton, do you have any questions for Ms. Smith?
No.
Thank you. Ms. Sheilor, do you have any questions for Ms. Smith? And Mr. Lindsay, do you have any questions for Ms. Smith?
No, but I would like to state that I went personally and looked at the properties. I've not talked with any of the parties, and I find everything that you have said to be entirely true. I don't understand, and you may not be able to respond, I don't understand how we got to the situation where they became unbuildable. I mean, clearly at some point, somebody drew property lines there that would have allowed, under existing code, construction of something there. So at this point, if it's not premature to say so, I'm very favorably inclined under the conditions that you described. Thank you.
Ms. Smith, I don't know if you want to respond to that or not, but
There are a range of historic lots throughout the city that at one time were buildable when they were originally created. Typically, when you go through a rezoning process, you do not do what is called spot rezoning, whereas you look at an individual lot and give it a specific zone or a specific set of requirements just for a particular lot, because the idea is to make lots consistent within a zoned area. And sometimes that does result in an anomaly such as we have tonight. The zoning ordinance envisions lots in LID of 20,000 square feet. The goal at the time of creating the ordinance would have been to combine lots such as to reach what was seen as the appropriate size for a lot in LID. However, it is against the law to render any lot undevelopable because of its existing format. In this case, the surrounding property owners are happy with the development that is on them and do not want to recombine to create a larger size lot, and they do not have to do so.
thank you, Ms. Smith.
Thank you.
Anything else, Mr. Lindsay, you would like to ask Ms. Smith? Mr. Lindsay?
No, thank you.
Mr. Bailey, any questions for
No
you?
questions.
All right. And the chair has no questions either. Ms. Smith, thank you.
Thank you.
At this time, the chair would ask the applicant to come forward. Yes, ma'am. If you would please state your name for the record, and if you could identify your association with the subject property, and then if you could describe your request to this board for purposes of granting a variance.
Sure. Hi, my name is Beverly Carlton, Beverly Forney Carlton. Actually, my family owned that 311 lot, and that was where I grew up. So it was a residential lot, and the lot next to us was always vacant. But we always took care of that lot just like it was ours. It was part of our yard. So at this point in time, we would like to go back and put something on that lot that could still be there for, as a resident for, for filling a void in our city right now that we have the need for affordable housing. So it would be an affordable housing unit. And my growing up, I didn't realize that it was such a small lot, but I do recall that the house initially, or the property initially was in the street. And back in the day, the city wanted to put the street there. So they had to move the house back. And when they moved the house back, they took a lot of the lot that was there originally to begin with. So my mom did go back and claim some of the property that was in the Bay Street area. And we don't know if she reclaimed everything that was lost, but there was a larger lot there that, because the city needed to put a street there, that was moved back. And the size that it is now resulted in that move back.
Anything else you would like to advise the board of before we start asking you any questions?
I think that covers it.
Well, thank you. Mr. Britton, any questions for the applicant?
No.
All right. Ms. Sheilor, any questions? Mr. Lindsay?
I can't think of any questions which would be adverse to her request. I have no questions.
Mr. Bailey, any
She was
questions?
very thorough. I have no questions.
All right. And I would agree, Ms. Carlton, you were very thorough in your presentation and your packet, and certainly am appreciative of that. The intent for the property is for you or your associates to build a single-use, family-use home there, is that right?
Yes, that's correct.
And I was impressed by the type of home you plan to build on that property. Can you forecast for the board roughly when you would intend, if the board were to grant your variance tonight, what sort of time frame you would be looking at to construct? I realize that's a hard question to answer, but what sort of time frame you've been thinking about for moving forward?
It is a tough question to answer because first we have to purchase the property, right, that's next door to us, and then we go into pre-development phase probably around February or March of next year. And then the construction would begin soon after that.
If I think one of the things that I'm mindful of is setback restrictions are certainly important for a city's zoning rules, and they're there for a reason. If this board were to grant you a variance, we would be deviating from those setback restrictions. If this board were to grant you a variance from those restrictions, if we agreed to place a condition on the approval such that you agreed to construct a single family use home on the property consistent with your application as you've described, would it be reasonable for us to place a time frame within which you could complete that project?
Why would you need to do that?
Well, I would be concerned that it never come to fruition would be my concern, and so I was thinking 5 years, 10 years, something along those lines.
Okay.
But that was my thought.
Mr. Chair, I'm not certain, not being an attorney, and certainly not being a real estate attorney, I'm not certain whether or not the board would have the authority to do that. It would constitute some variation of conditional use zoning or something, which we used to be able to do in North Carolina.
We certainly have the authority to set conditions on I just I don't want to be arbitrary with you, and so I wouldn't do that. But I do want to recommend to you, and I'll recommend that as we deliberate that we move forward, because I think if we're going to set, I don't have any further questions for you. Thank you.
But I do understand your question. Because if this is set like this and we don't construct on it in the next 5 years or so, then what's going to happen?
Right. And my concern would be why then have we made a variance to the city ordinance to change the setback restriction when no construction's occurred?
Yeah,
See what I'm saying?
I do. But also to add that that's how far back our house was
Right.
to begin with.
I understand. Right. I get it. Well, thank you. Before you leave, any other questions for our applicant? All right. Thank you.
Thank you.
All right. Madam, I'm sorry before you left. Did you have any other evidence that you wanted to put forward to this board before I dismiss you?
I don't know what else could be evidence other than to have a picture of the old house that sit on the property. I don't know of any other evidence
Okay.
that I could have, other than, you know, the need for affordable housing, and that is a lot that is vacant, combining the two, that we can put a house on.
All right.
And I understand, if I may interject, that at this point, at least one of those lots is completely unusable. Okay, thank you.
Thank you so much.
Thank you.
All right. Is there anyone in the audience tonight that would like to speak regarding this application? The chair not being aware that there's anyone that would like to speak on the matter. At this time, I would suggest that we move towards deliberation on the application and would open it up. And so we're in an orderly fashion. I would ask to start with my friend to my right, Mr. Britton, for your comments.
No, I think they've done a good job laying everything out. And to me, it's a pretty cut and dried situation.
Ms. Sheeler, your comments, please. All right. And Mr. Lindsay.
Yes, I agree that the case has been well presented, and that all four of the conditions that are specified in the legislation need to be met have been met, in my opinion.
And Mr. Bailey, your
I think
comments and thoughts.
It will improve the whole situation of that street, because if you look at it now, it's just a glob of bushes, and the improvement would help the neighborhood and help Morganton.
Thank you. Anything else, Mr. Bailey?
No.
I'd be interested in the board's thinking around my thoughts on placing a condition on the applicant that they move forward with their construction of a home consistent with what's forecasted in the application, and that they do so in a timely manner.
That's fair.
If I was, in Raleigh, I can recall when we had conditional use zoning, and it became terribly controversial statewide. And I thought that at least when it came as far as zoning itself was concerned, that the legislature pretty much, abolished the possibility of a conditional use rezoning. Now, this wouldn't be a direct rezoning, but it.
Well, let me read straight from the statute. So what the statute says is no change is permitted in a permitted use may be authorized by variance. Appropriate conditions may be imposed on any variance, provided that conditions are reasonably related to the variance. Any other development regulation that regulates land use or development may provide for variances from the provisions of those ordinances consistent with the provisions of this subsection. It would seem to the chair that the statute makes it very plain that this board has the authority to allow for appropriate conditions placed on an applicant. The applicant has forecasted to this board that she intends to build a home on 2 lots. She's asked for the lots to be conjoined for the purposes of developing a home. She's included in the application a model home that she's described to be constructed on the property. My condition is that she move forward in an appropriate time to construct the home. That would be my condition.
We have one comment, I believe, from planning.
Our application, or it's not in the ordinance, does note that unless otherwise specified, any order or decision of the board granting a variance shall expire if a building permit or certificate of occupancy of such use is not obtained by the applicant within 6 months from the date of decision.
Okay.
All right.
So that is in the application itself. Obviously, the board is.
Would that render your
Whether or not
your
that is.
consideration superfluous at this point, if that 6 month?
No, because it's my view, we still need to make it a condition of the granting of the variance.
Then the only remaining question would be how long that ought to be if the board were inclined.
The appropriate time would be my suggestion of the wording.
Typically, once a zoning permit, well, under 160D, once a zoning permit is achieved, it lasts for 1 year until that permit itself expires. So you may want to consider a timing for a permit, and then they have that time period already built into the ordinance.
Of course, my motion relates to the granting of a condition on a variance, and consequently, using the word appropriate time would allow for the inculcation of any sort of other related notion to what else might apply with regard to zoning and that sort of permitting and that sort of thing. Those other matters wouldn't be directly relevant to a condition on a variance.
What I was trying to say is perhaps the condition is related to the time period to achieve a zoning permit rather than to achieve construction, but how?
So maybe the wording of the condition would be consistent with the relevant time periods, consistent with this. I didn't want to necessarily tie it down. I was just going to use the vague words of appropriate time period. That appropriate, in my view, would give enough latitude to whatever she needed in order to be consistent with the rules. Would be my view. Is the board following me on that? The word appropriate being
The word appropriate.
being consistent with whatever the
But
rules
Appropriate
necessitate.
is operative.
I think you have a situation here with winter coming on, spring rains, the timing would have to be adjusted for bad weather over a period of time, then they could start.
Yeah, and that's why I was trying to be more liberal with the word appropriate.
Okay.
Are y'all comfortable with that?
Yes.
So at this time, what I would like to do, and I'm going to read these as findings of fact, and then I'll entertain a motion to endorse this finding of fact, that this board would grant a motion to grant a variance to the city's zoning and planning zoning ordinance to demonstrate that there is an unnecessary hardship to the applicant that would result from a strict application of the regulation, that the hardship does result from the conditions of the peculiarity of the property, such as its location, size, and topography, and that the hardship did not result from the actions taken by the applicant or the property owner, and that the requested variance is consistent with the spirit, purpose, and intent of the zoning regulation for the city of Morganton, such that public safety is secured and substantial justice is achieved, with the added condition that the applicant move forward in an appropriate time period to, consistent with the applicant's application, construct a single home residence on that conjoined properties of the two lots at the Concord Street property. Is there a motion to accept these findings?
So moved.
Motion's been made. Is there a second? The motion's been seconded. Any further discussion? Hearing none. All in favor say aye.
Aye.
All opposed, like sign. In the consideration of the chair, I'll vote aye as well. That's 5-0 for purposes of the minutes. 5-0. Motion passes. Thank you so much. All right. Good luck to you. All right. The next matter we'll take up is the Lane Street property. And at this time, I would ask the plan and design representative please come forward and give testimony concerning that application. Ms. Smith.
Yes. Just get Todd back. So the second application is very similar first, and that it is asking for a reduction in setbacks due to the narrow depth of existing historic lots. This one is on Lane Street, as noted. This is two separate properties, and we are asking for the reduction on both of those properties to be able to be developed separately. Those properties are roughly 66 feet in depth, so a little bit larger than the last one. They have asked for reduction only in the rear setback from 20 feet to 10 feet. This one has the added factor of a significant change in topography across the sites. It's a bit hard to see in here, but this line is 1,100 and this line is 20 feet. So across that 66 feet, you get a 20-foot change in elevation. In addition to having quite a narrow lot there, it rises towards the rear. So the idea is to slide the properties, keep a consistent street frontage, slide the properties back towards the rear. It shouldn't impinge upon the neighboring properties because they're at a 20-foot higher elevation than the properties below them anyway, to be able to allow them to be able to be developed with a reasonable size home. Again, there is an example home that can be created in your package with those reduced setbacks, or one reduced setback.
Anything else, Ms. Smith?
That is all.
Mr. Britton, any questions for Ms. Smith?
No.
Ms. Shelor? Mr. Lindsay?
No.
Mr. Bailey?
No.
The only question I have, Ms. Smith, is I was curious about the issue around I read where there's one of the concerns about the property is the fact that at the back, the property does decrease down a bit there. Is that true for all along Lane Drive?
You mean the elevation?
Elevation, I'm sorry.
Decreases?
Yes.
From what our mapping is showing us, it is, I don't know if it's all along Wayne Drive, because it's actually quite a significant
But is it
portion,
consistent
but
for adjacent
consistent
lot?
across those lots, yes, sir.
And those lots have the same site restrictions as the lots that we're dealing with tonight?
I'm sorry, I'm not sure.
Those lots have the same setback restrictions?
Yes, sir. Yes, those adjacent lots.
If I may,
Ms. Smith, I don't have any other questions.
Yes,
It
sir.
appears to me that my colleague, Mr. Lindsay, has questions.
Yes, sir.
if you would go back to the map for a second, I noticed while driving through, and I noticed also by looking at the county's GIS, whoever subdivided that had lots that were just beyond that were,
The north,
they changed the alignment at that point, just when you go a little bit beyond that,
to the north here on this map?
yes.
Yes.
The lots are all the way across, and it was only when they were reaching these particular lots that they put
They felt that that
That
point
they
in time,
faced
they were
both.
wide enough.
the separate roads. So it looked to me, and if I'm wrong on this, and obviously you can't speak for the folks who did the original subdivision, that they were aware of the topographical differences and that these lots were the ones that were most immediately hit with the greatest problems in terms of the declination.
Yes, sir.
So,
As I said, I can't speak for them, but that seems eminently logical to me that it would have been particularly at the time that those lots were originally subdivided, quite an engineering feat to develop a house across that grade difference without just cutting and filling the whole
yes,
thing.
so they were hit by topographical differences much more acutely than the lots on either side, the ones that
Correct,
beyond them and the ones that were, further up.
correct. I think there's a couple more, the ones that are 75 feet in width to the south there are probably developable, close to developable the way that they are. I'll leave that to a formal developer to be able to make that decision. But definitely once these narrow up is when you start having the issues in there.
Thank you very much, and thank you,
sir.
Mr. Chairman.
Any other questions from the board? Ms. Smith, anything else?
Just that this one is in zone MID, whereas the other was in LID with the greater front and rear setbacks anyway. So this one, when you compare it to the previous site, the setbacks were larger for the previous site that are on the base standard requirements. Thus why this one is not asking for as great a reduction of setbacks, because the setbacks aren't as large to begin with.
Thank you, Ms.
So,
Smith.
Thank you.
The applicant would come forward. And welcome, sir. I appreciate you being here tonight. If you'd please identify yourself, if you would also describe your association with the subject properties, and if you would also describe for the board why it is you believe we should approve your request for a variance.
Okay, my name is Mark Cox. My company's name is NC Land and Lots. I'm a real estate agent and a developer. And I have purchased in the last 6 months 5 designated locations to be putting affordable housing in the Morganton area. On this purchase, which is pending based on variance, is there's 2 lots basically that we can put a 900 to 1,000 square foot home if the variance is approved. If they're not, we can go what they do in Asheville and put a 300-foot box and make a skyscraper, which some people like and most people don't. So we are trying to build something that's conducive in the neighborhood, saying how it is right around the corner from I think Roses, and it is a older neighborhood. The product that I sent to you was something with a small front porch and a 1,000 or 980 square foot 3-bedroom 2-bath, because we have city water and city sewer. This provides an affordable home for somebody that desires what I call a first-time home in a small community or a retirement. But with the variance so tight, it makes the building a challenge, if not impossible. And therefore, if we buy the property, then we have to lose, our equity situation simply because of the fact of the rules that were now placed on it that probably originally weren't even applied when they subdivided the property. So that's kind of where we're at.
Thank you, Mr. Cox. Anything else you would like the board to be aware of before we ask you any questions?
Basically, she's been very thorough. She's been very helpful. I want to give you a kudos. Great gal. I've worked with other cities in the area, and she's very pleasant. So I wanted to give her a kudo. She's done very well.
Ms. Cox, before we engage in any questions that we have for you, I want to take a point of personal privilege and ask you questions related to your relationship to the property and how you came to have that relationship. Did you engage in a commercial transaction with the Blue Ridge Healthcare Foundation?
We are currently under contract with the pending of sale based on variance, because again, it's a revenue reality.
Okay. So, members of the board, at this time, what I'd like to do is disclose to you all, as you know, I am the Chief Legal Officer and serve as the Senior Vice President for Corporate Services for the corporation that does business as Blue Ridge Healthcare System, Inc. You know that we operate as UNC Health Blue Ridge here in the community. We also have an arm of our corporation that is the Blue Ridge Healthcare Foundation, Inc. And the sole obligation of Blue Ridge Healthcare Foundation, Inc. is to raise money on behalf of Blue Ridge Healthcare System, Inc. I will tell you that I was not involved directly in this transaction, was not aware of the transaction directly, haven't done any legal work on behalf of the transaction, and just had a generalized knowledge that the foundation had received a donation of property to it. And of course, when our foundation receives a donation of real estate, as with any foundation, its key objective is to move as quickly as possible to move that property out of it. The foundation is not in the business of owning real estate. And so I gather that it has worked on a contractual arrangement with this gentleman, a developer of real estate. And so I wanted to disclose that because of the potentiality of a conflict of interest. I don't feel uncomfortable proceeding tonight But I certainly wanted to start first and foremost with the applicant and ask you, sir, if you felt the need for me to recuse myself tonight and not participate in these deliberations. I did want to let you know that the necessity for a vote is that there be a 4/5 majority. I certainly, if you don't feel comfortable with me participating, will step down and leave it to these folks to decide the question. If you feel comfortable with me continuing, I'll be happy to do that. It's up to you.
The only question that I would have is, are you attorney?
I am the lawyer for Blue Ridge Healthcare System, Inc. Yes, sir.
Do you think there's any legal realities that would be of conflict of interest?
No, sir, I don't. I don't think there's anything with regard to the North Carolina State Bar or with regard to my relationship with Blue Ridge Healthcare that would cause me not to be able to serve tonight in an objective manner on this question.
Well, I'm not an attorney, so I wouldn't know if that's right or wrong, but I'm relying on your reputation that, you're making a honest statement about the situation. In doing in contractual work with Blue Ridge, everything that I have done and everything that we've done as far as making the purchase and making the agreements and all that have all been through their board.
Right.
So therefore, it's not one individual making that decision. So I think collectively, the board has said that we're going to go to the variance. They've agreed that. And so I think they're in full agreement that whatever the board puts together, they're willing to work with.
And that's been my understanding as well, is that board of directors has made the decision to make that transaction. I've not influenced that board. I haven't been in attendance at that board meeting when that decision was made, and so that's why I'm comfortable tonight.
As I said, I'm not an attorney.
Yes, sir.
So, I'm asking your expertise as an attorney to make
Right.
that call. And if you feel that we're okay, I'm okay.
I do. I then would ask and turn to my fellow board members and would ask if there's any objection from anyone here tonight that I should recuse myself in light of what I've disclosed to you.
No.
All right, so,
I don't feel a need for that. I'm not an attorney again, but I don't think the city is going to run any risk with respect to this either in terms of your continuing to chair the board on this particular case and vote on this case if you choose to do so.
So hearing no objection from my fellow colleagues on the board, Mr. Cox, it would be my intent to move forward in the administration of this hearing, and we'll do so in an orderly fashion. And I would ask at this time, Mr. Britton, if you have any questions for Mr. Cox related to the application.
No, I think it's cut and dried. The information is good.
Ms. Shelor? Mr. Lindsay?
I have no questions that would be adverse to the case. I think it's been well presented and very persuasive.
Mr. Bailey?
No questions.
Anything else, Mr. Cox, that you would like for us to be aware of or take into consideration with regard to your application, your chance for a final statement to our board?
Well, I think she's reflected that the property is not prime building location.
No.
And if you've drove by it, you really basically say, how are you gonna put a house up there?
That was my first question.
It's true, I figured you would. Well, as I said, because of the fact of the conditions and the state of the economy, builders are looking for buildable property. And one of the things that we provide as our company to the builder is a buildable lot that has all the snaggles taken out of it. One of the problems we have is the variance, because that's the first thing I'd run into. They'd buy the property and walk in and say, hey, I want to build this house. And she'd say, hey, you can't do that. So that's one of the reasons we're stepping ahead, doing this ahead of time, so that when we start bringing in, builders, that we have all these rocks raked out of the sandbox.
Mr. Cox, I was very impressed by your
pretty
sample of type of home
Yeah.
you would put on.
We're looking to put in a cottage-type home with people that are trying to build under the 220 mark, and I think that's affordable. The interest rates are still nuts, but I've learned and I've seen that the lenders are getting creative, and they're starting to offer packages that you didn't see for a while. So they're getting back to that because they have to survive like anyone else. So if the economy mellows a little bit, maybe by April or May, because it'll take us that long to get all the planning done. I think we'll have something. Now, one of the things that my company does do is we do a pre-construction. Immediately, you were talking about how fast can we move on something. Immediately, once we sign the contract and we have all the rocks cleared away, we will show a pre-construction home available for immediate construction. And all the person has to do is, put A, B, and C together and, get the loan, get the lot, and get the house, and we can start building.
So you'd be comfortable with a condition that you comply with the application as you've described for a single
Oh, yeah.
use residential?
As far as the
property
timeline's
in an
concerned,
appropriate time
yeah.
period.
I mean, you were talking 5-6 years. That's insane. Market will be different.
Yeah.
Probably have a new president, and the world will be,
Yeah.
who knows? So we'd like to work with it. We would like to work in the confines that are presently involved. And, like I say, we will initially, as soon as we get this sold and sale, I've got 3 builders lined up that are anxious to build there. And what we're gonna do is put pre-construction homes. There'll be one of this type and one of this type, and put it to the public, and the public is pretty responsive. Usually Zillow, what everybody looks at anymore, we usually get anywhere between 600 to 1,000 looks on a property like that within a month.
All right.
Has that answered?
It does. Anything else, Mr. Cox?
No? Any questions?
I think we're done.
All right,
Thank you, Mr. Cox. We're going to deliberate now. All right, Mr., you can have a seat. Ms. Britton, any comments from you?
No, everything looks good to me, as far as the information and stuff.
Excellent. Ms. Shelor, comments from you? And Mr. Lindsay?
I'm satisfied, thank you.
Yes, sir. And Mr. Bailey?
No.
So the chair is satisfied as well, and I'm interested as well in conjoining a condition on this that, he move forward with, consistent with his application, that this single-use residential home sample as be part of the, in an appropriate time, be part of the conditions. And so with that, what I'd like to do is read the findings of fact for us again, if I can find them. And so the findings are, and that I would receive a motion to this effect, that there is a unnecessary hardship with regard to the subject property that would result from the strict application of the ordinance, that the hardship results from the conditions that are peculiar to the property, such as location, size, or topography, and that the hardship did not result from actions taken by the applicant or the property owner, and that the requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that the public safety is secured and substantial justice is achieved, and that lastly, the applicant will move forward with regard to the construction of a home consistent with that which is described in the application in an appropriate time and manner. Do I have a motion to approve that question?
So move.
Motion's been made. Is there a second?
I'll second it.
Motion's been made and seconded. All those in favor, please say aye.
Aye.
Those opposed, like sign. And Mr. Cox, just for purposes of this question, given the fact that I did announce a potential conflict, what I'd like to do is, since only 4 votes are necessary to approve your question, at this time, I would like to announce an abstention and not vote on the question, such that, Madam Secretary, the question will be decided in the affirmative for 4 votes to no no votes, and 1 abstention. Therefore, your matter is approved. And any other business for purposes of the City of Morganton Board of Land Use Adjustment for tonight? In that case, the board chair will take the prerogative of declaring an adjournment. Thanks, everyone, for being here, and thank y'all for your participation in the City of Morganton, and good luck in your projects.